Welcome back to the Law and Crime Network. Aaron Keller here, along with Mike Koribanics. Mike, it's good to see you. Good to see a bow tie on a snowy day like this here in New York City.
Nice to be here.
Reminds me of warmer climes with the purple and whatnot. So, hey, look, we're going to bring you right straight back into the David Dooley case out of Kentucky, where a man is accused of killing his coworker. The state says that some of the motive was wrapped up in people cheating on their timesheets at work. But the defense says the timeline doesn't work, that he must have run home, cleaned up, and come back to work in 30 minutes. That's a heck of a cleanup after a bloody crime. Let's listen back into testimony. A pause in testimony there in the David Dooley case out of Kentucky, where that defendant is accused of killing his coworker. The state is saying that the motive here is time cards, that people were cheating on their time cards at work. The defense says this doesn't make any sense because when you add it all up, it just doesn't roll out the way that it should. Mike Koribanics is here with me now. So, Mike, this is a case where we've got a state suggesting a motive. Do they really want to get buried in that, though, if it's not ironclad?
The motives are very dangerous in these kind of cases, especially if the motive is something that isn't strong. I don't think cheating on your timesheet would give somebody a motive where they'd want to go kill someone or put themselves at risk to kill somebody. It almost goes back to when we talked about McStay. It's funny, we keep talking about these like almost wholesale kind of motives, $4,000 a timesheet. I would stay away from that motive because I think it's going to be a tough one for people to really digest on the jury.
Yeah, stick with what you actually have to prove here. Now, you know, the defense is saying this guy must be the best janitor in the world, that he basically could have left no DNA at the scene, cleaned it up, ran out of the building, got nothing on him that police could find in his truck, in his home, ditched all the tools he used, everything, and then made it back to work in half an hour.
That seems like, I think the defense is pretty strong there, and I think they're pretty strong there because, you know, when you have that theory and you couple it against this crime scene detective who's telling you how much blood there was, how much all these things could be contaminated, cross-contamination, things of that nature. And then on the other polar opposite side is the defense saying, well, then you should have found something that would tie him to the crime, and he couldn't clean up in that kind of time.
Yeah, we're going to take a break here on the Law and Crime Network and come back with more live testimony in the David Dooley case out of Kentucky in just a moment. A sidebar here in the David Dooley murder case out of Kentucky, where that defendant is accused of killing his coworker, tying her up. Just a big mess here. Mike Koribanics, you've been listening to the testimony this afternoon. Does the state have a strong enough case here to say that it was these time cards, that he was trying to get into an office, that people were lying and altering time cards, that there was a lot of money tied up in this and they wanted to get rid of somebody who might have been able to put a stop to it?
I don't think that's a very good motive because, you know, when you talk about a motive like that, usually a motive for a murder would be one person has the information. But if people were talking about the time cards, a lot of people had the information. So that would seem to be like really a non-motive to do it because it would be drawing too much attention to the people because they all had knowledge of this scam, for lack of a better term, of these time cards. I don't like that motive, and I don't think it's a strong enough motive for people to say this would cause somebody to this brutal of a murder. This seems sort of like something done out of rage.
Yeah, okay, so one of the questions, though, is was that defendant acting strangely? Were his movements rather bizarre? Because they're saying he happened to leave work and, you know, took off and went home. And first he didn't say anything about it. And then he said, oh, I was going home to tend to my wife. And then he strangely approached a coworker in the parking lot who he rarely ever talked to, just walked up and said, oh, you know, I had to go home because I tore a hole in my pants. So according to the state, there are three different versions of this story about just what he was up to. And because they never found any of the weapons, so to speak, at the scene, they think the person who did it must have left the property somehow.
Well, that could lead to conjecture and speculation. But who knows why maybe he was trying to justify the fact that his timesheets were off. I mean, it seems curious, and it seems like something would make you want to investigate further. But is it something I'd want to put in front of a jury for proof beyond a reasonable doubt? I don't think so.
Yeah, is it one of those things where he wasn't supposed to go home, and he figured he might have to concoct some kind of story because he thought he was going to get in trouble with his boss, and then this other thing was going on? I don't know. It's kind of a bizarre situation, though. We're going to take a break here on the Law and Crime Network and wait for testimony in the Dooley case to resume, hopefully when we come back. We're covering two big trials this afternoon here on the Law and Crime Network. There is an afternoon break in the David Dooley case out of Kentucky. That's the case of a man accused of killing his coworker. We're waiting for testimony to pick up in that. It should be happening in about 10 or 15 minutes. There's the coworker, Michelle Mockbee, on your screen right now. But some developments in the David Holbrook case we're following out of Florida. This is a really interesting case where a man is accused of killing his friend's estranged wife. Now, here's the development. They wrapped up testimony in that late this afternoon because they're trying to settle out an evidence issue. Here are the facts as related in a session that was held outside the presence of the jury. Apparently, the state wants to call the victim's divorce attorney to testify about a very strange, suspicious phone call. Victim Melissa Howard was getting a call from her attorney. The attorney's name is Janice Burke. Burke called that victim right there, Melissa Howard. The victim was crying. Melissa Howard said her husband sent the defendant to her house to scare her, and that the defendant said, "You need to let that boy be with his father." Now remember, one of the issues underlying this case with this split between this man and this woman had to do with child custody. And one of the theories is the defendant somehow got involved in this for some reason. That's the statement made to this attorney. And the state wants to get this in. Mike Koribanics, they want to try to do it under an excited utterance exception to the hearsay rules. It's kind of an interesting way to try to wiggle it in.
It is. I mean, I always think the excited utterance, dying declarations, those rules of evidence really leave a creative avenue for attorneys. When you hear this kind of testimony as being an exception to the hearsay rule as an excited utterance, it will give a court much to think about, but the court better do a very strong balancing act on how much this is needed.
Yeah, exactly. So that's exactly why the judge said, let's just put a break on this proceeding right now and give the attorneys time to cite cases, come up with some briefs, say in the morning, this is why you should rule one way, this is why you should rule another way. My guess, though, Mike, is that I think that they're going to bring this in because in Florida, there's an expanded definition of the excited utterance rule. Federally, it has to literally be an excited utterance. Like I'm talking to you and all of a sudden a buffalo crashes through the wall behind me, and as it's happening, I say, "Oh my gosh, Mike, watch out, there's a buffalo crashing through the wall." It's got to be extemporaneous. It's got to be basically the witness, the declarant, saying something extemporaneous with action. And the presumption behind it from a policy standpoint is that we let that in under the hearsay rule, because if I'm watching something, I'm startled by it, and I'm basically doing a live play-by-play of what's happening, my brain doesn't have time to filter it and lie. You know, the hearsay rule is to try to get out from underneath the lie. So the possibility of a lie happening. So if I'm perceiving something immediately and immediately saying that's what happened, it must be true.
Well, that's the interesting hook, I think, here, where it's going to be difficult for them to get that statement in, because the example you gave is a classic example of it. Here, you see, in your example, there's no time for fabrication, nor is there motive to fabricate. I think one of the tough hurdles they're going to have is she was in a custody issue, so there may be a question as to the reliability of that statement to her attorney as to get an advantage in court over her husband's actions. I think that's where the argument lies for the state for the defense to try to keep that statement out.
In the federal rule, I would agree with you. It would be very tricky to do this. But in the state rule, Florida has relaxed this because some states have, because a lot of prosecutors want to try to get things in and fly them through this excited utterance exception. And the way Florida says it is a statement or excited utterance relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. So the attorney is saying, I called up just to do whatever, okay? Random call, conduct routine business. She was crying and she told me that my husband sent this defendant. I found him in my house. He was there to scare me, and he brought up the custody situation. That links the defendant to what's going on there, because for a while, they didn't know exactly what was up. And remember, the ex-husband was at this big party with everybody.
Well, I still think
so under Florida's rule, I think that it might squeak in there because the attorney said that the victim, Melissa Howard, was crying.
I think
she was under the stress of excitement caused by the event or condition.
I think the state has a very good argument here. But playing the devil's advocate or being a defense attorney, I can't help but be, is to really cut at the spirit of that rule, even though they may have legislated it one way, but it's still the question of fabrication. The only problem is I think the state has a good argument saying, well, Judge, she didn't call the attorney. She was not the catalyst for this call. The attorney, it's almost like if you come upon someone crying in the street, what just happened? That's almost the same analogy. So I think the state has a good chance of getting us in.
Look, big questions here. Is this voice from the grave from victim Melissa Howard going to wind up in the trial, and could it be the key piece of evidence that sends this particular defendant away? That's the question attorneys are mulling over. They're drafting their arguments. The judge is going to consider it in the morning. And if that attorney takes the stand, that could be the key to the state's case. We're going to continue talking about this case. Let's listen to some previous testimony from earlier today from a forensic pathologist on the witness stand.
And these are the injuries on the neck, of which I did not mention one of them to you, but I will now. There's one right under her jawbone, and it's not perfectly straight. It's actually slightly curved, crescent-shaped. And the top part of it, or the part going back toward the ear or back of the head, actually is skin-scraped, and I regarded that as having a contour that could have been made by a fingernail. That was my observation at that time. But in addition to that injury, there are the other two stab wounds and some smaller little skin scrapes on the neck as well. The lower stab wound that I listed as B, and that went through her Adam's apple area, is that straight line right next to my photo card. The first wound that went through her jugular vein is now currently more gaping until I bring it back together, but that was my upper stab wound A.
I'm going to go back one photograph so the jury can see the straight line of what we're looking at right now as compared to the prior photograph.
That was some testimony from the forensic pathologist on the stand earlier today in the David Holbrook murder case out of Florida, where that victim, Melissa Howard, was found stabbed in her home by her own daughter. Let's listen now. Some of the defense's opening statement, they say the timeline just doesn't make sense in this case. Actually, Mike, let's flip to you first. So we heard from the forensic pathologist, but we heard some pretty compelling arguments from the defense. They said, okay, look, the timeline doesn't make sense. It's not the defendant being shifty when he changed his timeline. It's just he's trying to remember down to the minute-by-minute detailed account of exactly what he was up to when all of this was going on. And they said he must have been Superman. Another half-an-hour window here. He must have gone to the house, committed the crime, basically, stabbed this victim to death, left no blood on himself, didn't change his clothes, and then went back to this birthday party that he was at. That's an awful lot of fast moving, the defense is saying.
Well, that's the problem when the prosecution tries to tie itself to a timeline and things of that nature, because timelines really sort of imply an accuracy that can't be moved. But when you get testimony, you got witnesses coming, and there's not film or things of that nature, it's very difficult to stay to that, and it's really easy for the defense to poke holes in it when they stay so committed to a timeline.
Yeah, I want to listen now to some of the way the defense tried to frame this all up. They tried to wreck the timeline during opening statements.
The state has already admitted that they believe there's going to be testimony that shows that Russell was at a birthday party, and there's going to be witnesses that he was there at the birthday party, including his daughter Danielle, his brother Michael, Michael's girlfriend, Melissa Soule, and others were all at this birthday party. And that sometime around 8:45, that he had to start rounding up people to go bring Danielle and Ryan back to their house, Darlene Cooper's house. And that the instructions had been, and the states even in their own opening agreed that he was supposed to be roughly there around 9 o'clock. Now, the state has also stated that there's going to be a phone call that was made by Danielle. That was roughly around 9:24 that night. After she got dropped off, and shortly after being dropped off, she makes a phone call at 9:24 p.m. Shortly after that, there's going to be testimony that another phone call is made at 9:29 from Russell Holbrook to Gina Baker. And I'm not sure we're going to hear what the contents of that statement were, but a statement was made, a call was made at 9:29 to those two individuals for him to pick up some medicine. So Russell and his brother, who was riding with him, go to Walmart. Y'all are going to see a video of Walmart. It's going to have timelines on there. When these individuals went into Walmart and when they left. One video says they arrived at 9:35. One says they arrived at 9:37. What we do know is they left at 9:40. And shortly thereafter returned back home to the birthday party. Left, dropped kids off, went to Walmart, came back home, all wearing the same clothing. There's nothing on these individuals that would indicate that Russell had been in any gruesome murder during that time frame, during this timeline. It's going to be very difficult, I believe. I think the evidence will show it will be very difficult to have done this so-called murder. Just didn't have the opportunity. There's problems. Not enough time. Just not enough time to have done.
Okay, we heard the defense there during opening statement say there just wasn't enough time for this defendant to have committed this crime because he wouldn't have had time to clean up. Let's listen to the defense score a couple of those golden nugget points from the forensic pathologist.
Depicts some blood splatter on a wall at the scene of the crime of the Melissa Howard's house.
Yes, sir.
Possibly be put on the assailant or whoever was killing Miss Howard at the time.
I cannot say for sure. What I can say is this has spattered toward a wall above her head. To clearly have gone on to someone next to her, obviously they would need to be above her head by the wall. Perhaps some of this spatter also spattered below her head, and if the person were close enough, there could be transfer. But if they're farther away and it's actually spattering out this way and they're back there, I wouldn't expect it.
Would you agree that that with these knife wounds that we're dealing with some pretty close to each other during the struggle? Is that correct?
Yes.
So it is possible you believe that some of the blood splatter could have transferred onto the assailant?
The defense scored a couple of good points there in that cross-examination of the forensic pathologist. We will take a break and be back with more live testimony in a different case, the David Dooley case, when we return. All right, we've been listening to testimony looking at pictures taken from the Michelle Mockbee murder scene in Kentucky, where defendant David Dooley is accused of killing his co-worker, Mike Koribanics, defense attorney here on the Law&Crime Network. They're putting a lot of these pictures in just to sort of explain. We looked at everything. We looked at the dot on the wall. We thought maybe it was something, but it turned out to be nothing. It seems that this particular detective is trying to make jurors know that they looked under every stone, they tried to find everything they could, and it increases its credibility.
Yeah, you know, I've been watching him testify, and that's a technique, but I don't know if it's an effective technique, because we've been hearing a lot of nothing from this witness. You know, this didn't mean anything, that didn't mean anything. And it sort of seems like I think jurors want to have concise, factual,
as to whether or not you want to impeach your own witness. And sometimes, and in some states, you can impeach your own witness. You can under the federal rules. There are some states where you can't. So he wants to probably get up there and say, okay, I looked at everything, and then this is what's important.
That's where I think you want to go with that. But I still think the defense then gets up and goes, well, you didn't find this. That was nothing, but you looked at it. That was nothing, but you looked at it.
But
it's almost like you're trying to find that pin in the haystack.
The state was honest about it and brought it up first. Mike Koribanics will be back in a couple of seconds here on the Daily Debrief. Of course, if you want to continue watching the David Dooley case, it's live on lawandcrime.com. They might be going for a couple more minutes before they wrap up at the top of the hour.